Welcome to another episode of the podcast with me, your host, George Chintangwa Malipilo, and this is my 2 cents Zambian case law podcast, the first one for the year of 2022. So welcome and thank you for being here. The citation for today's case is Sithole versus Sithole, a 1969 judgment that is found at the Zambia Law Report, page 92, and it talks about divorce. But it also talks about the conversion of a legally valid customary marriage into a legally statutory marriage and whether the law does permit such a conversion. Now, the brief facts of the case are that the petitioner and the respondent contracted a validly customary marriage under the Ngoni tribal customs in January 1959. After living together for a period of 6 years, they decided to actually then contract a second valid marriage. Now, this valid marriage was of a statutory basis. So it was a statutory marriage at the office of the Registrar of Marriages in Lusaka at the Civic Center on 10th July 1965. Now, having lived together for a while, the petitioner brought a petition that the marriage be dissolved. And this was before the High Court, claiming that the marriage had irretrievably broken down, and the fact for that irretrievable breakdown was the behavior of the respondent, and that this caused injuries to the petitioner's health, and the petitioner couldn't endure this anymore. The law that the court had to decide, or the issues that the court had to decide, were: one, which among the two valid marriages was the one which was constituting at the time of the petition. The second one was, did the Marriage Ordinance Act allow for such a conversion from a potentially polygamous marriage to one of a monogamous nature? And finally, did the High Court actually have jurisdiction under the Matrimonial Causes Act to even entertain this petition before they adjudicated upon it? The conclusion of the High Court of the Republic of Zambia was the fact that this marriage was legally converted from a monogamous or potentially polygamous marriage to one of a monogamous nature. According to them, they say that the Marriage Ordinance Act at the time allowed for a person who was married under customary law to marry his customary spouse under the second marriage. And the second marriage was also valid. But the second marriage superseded the first marriage and took over, and therefore the rights of the first marriage no longer applied. The rights of the second marriage came in. So the first and second question were answered. The third question was also answered on the basis that because this marriage was now of a statutory nature, it therefore meant the fact that the court had jurisdiction to adjudicate upon the matter because it was monogamous, governed by statute. So, in summary, the importance of this case is basically: one, the law at the time and the law now still allows for the conversion of a marriage from a statutory or from a customary perspective, meaning the practices of your tribe, to a statutory marriage. And in our current law, which is the Marriage Act number 50 of the laws of Zambia, you have section 32 and you have section 38, which allow for such type of conversion. But this type of conversion should only be married to one person. So from a customary perspective to a statutory perspective, so the one person you're married to under customary law, you can convert that marriage. And once you convert it to a statutory marriage, the first valid marriage falls off and is of no use, and you of a monogamous nature, meaning you can't marry anyone else. If you do so, that will be bigamy. Secondly, the court has jurisdiction to hear that matter once the marriage is converted from a polygamous marriage to a monogamous marriage. The talking points, or my 2 cents talking points on the issue, are basically: first, the laws governing marriage in the Republic of Zambia, which are obviously customary marriage on one hand, and secondly, statutory marriage, regulated by the law, which is the Constitution of the Republic of Zambia and the Marriage Act. Now, these two don't mix. So it's either you get married under customary law or you get married under statutory law. So you can do both. One, you start off under customary law, like Sithole versus Sithole, with one partner. That same partner, you convert that customary marriage into a statutory marriage. That customary valid marriage will no longer subsist once you decide to have it monogamized, if that's a word. So monogamization, if there's such a word, would mean you're only married to that person and you can't marry again. So you could take the current trend that Zambians do of paying lobola to the parents of the female. That is your customary marriage. Then you get married in a church. That converts it into a statutory marriage. Legal. Now the legality of this is that it's possible, you can convert it, but it has to be with one partner only. If you decide to get married under customary law, then you decide to marry another woman under statutory law, you will be arrested. That is called bigamy. The reason why the High Court was so concerned with whether they had jurisdiction of that petition is on the basis that the courts only hear matters based on the recommendation or based on the guidance of the law. So our courts are useless without the law. The law tells the courts what to do. So in this case, under our law, our High Court only has power to adjudicate, listen to, marriage cases of a divorce nature, or divorce cases from a marriage if it was contracted in accordance with the Marriage Act. So the reason why they hate this Sithole versus Sithole case was the monogamous marriage that converted it from a potentially to a monogamous marriage meant the marriage was now under the Marriage Act. If they had found that it was customary marriage, the court would have thrown out the case because under the Matrimonial Causes Act, that marriage does not fall within the statutory definition of a marriage, monogamous marriage, because that one is potentially polygamous. So the fact that it was monogamous and they went to the office of the registrar of marriages, it fell under the jurisdiction. Now, jurisdiction, for those of you that are wondering, is just the legal authority that the court has to hear a matter. So a court can only hear a divorce petition if the marriage was solemnized in accordance with the Marriage Act and the office of the Registrar of Marriages, and you show proof. So that is all for today's case. I hope you learned one or two things. So basically, a polygamous marriage can actually be converted into a monogamous marriage, but you must only have one partner, regardless of the number of years you've gone for. You can have gone for 25 years and said, you know what, let's change it into now a monogamous marriage. But you must only have one partner. And that in Zambia, the laws regulating marriage are either customary, which is based on practice, or statutory, which is based on the law, and they are separate. But you can convert from customary to a monogamous marriage. I'm not sure if you can convert a monogamous to a customary directly. You have to first of all divorce, then marry someone else, and make it a potentially polygamous marriage. So this has been your host, George Chintankwa Malipilo. Thank you for listening to the podcast, and I will see you next time, and have a lovely week.